Good day, everyone. Today we'll be discussing the Family and Medical Leave Act of 1993, which is a very important benefit that all employees, not just in Michigan, but within the United States, have available to them. Here we have some background information and purpose for the Fmla Act. It was enacted in February 5th, 1993 by Senate and House of Representatives under Bill Clinton's presidency. The purpose was to grant family temporary medical leave under certain circumstances or events, and this is overseen by the Department of Labor. This is for a balance of work and family in order to take care of a relative, promote equal opportunity employment, and minimize discrimination by sex, and to protect employment. What is considered a qualifying event for FMLA? We have the birth of a child, adoption or foster care, the need to care for a spouse, child, or parent with a serious health condition, or the need to take care of yourself. Some examples of a serious health condition would be Alzheimer's disease, chronic back conditions, cancer, and diabetes. An example for self-care would be a high-risk pregnancy. Here we have the requirements for an employee and an employer. An employee must work at least 12 months and have worked at least 1,250 hours prior to taking or attempting to take a leave, and the employer must be a public agency or, if a private sector, at least have 50 employees or more, or multiple locations across a 75-mile radius. Who and how is FMLA enforced? The Department of Labor Wage and Hour Division enforces FMLA by investigating any claims that are brought to their attention. The Department of Labor can bring this issue up in court and compel compliance on behalf of the employer. An employee may also bring a private civil claim against the employer. All allegations must be brought into light within 2 years of said violation. Here we have state and local versus federal law. And what this is indicating when it states that nothing in this act shall be construed to supersede any provision of any state or local law that provides greater family or medical leave rights, means that if the benefits are more beneficial or generous at the state or local level compared to the federal level, those benefits will trump the federal law. Normally, federal law trumps all, but in this case, if those benefits are more generous towards the employee, the state or local law will trump the federal law. Here we have a case where an employee's FMLA rights were violated. We have the Department of Labor versus Michigan DHHS and Kalamazoo Psychiatric Hospital. We have the employee Cavender, who was employed by Kalamazoo Psychiatric Hospital, where he had been employed for at least 12 months, working at least 1,250 hours. And the hospital did employ at least 50 employees. So here we're meeting both the employee and employer requirements. June of 2015, Cavender made 2 separate requests to apply for FMLA to care for 2 family members with serious health conditions that did meet the FMLA requirements. During this time, they failed to promote Cavender to assistant director of nursing and expected him to complete the work of a full-time employee while on leave. This is a violation of his FMLA rights because during this period of leave, they are not required to perform any work as a full-time employee would normally do so. As we can see, the U.S. District Judge the HHS and the hospital to pay the nurse over $30,000 in back wages, retirement contributions, interest, and liquidation damages. Here we have a situation where an employee faces retaliation after being approved FMLA. The employee was fired after taking a vacation to Mexico while on FMLA. The employer had requested to return to work early after their surgery in order not to exhaust all his time off. The employer rejected the request, indicating they needed a letter from the surgeon. Since the surgeon was out of the office for a few weeks, this was not a possibility. The employee then requested to be paid under the salary continuation policy, and when he did not receive the correct payment, he reached out to HR and requested a copy of the policy. The employee never received a copy of the policy, and this information was forwarded to the HR director. During this time, the employee took a vacation to Mexico, and upon HR finding out about the vacation, they launched an immediate investigation. The employee had the vacation approved in their regular work schedule prior to taking FMLA. During trial, the HR director testified to her belief that an employee on FMLA could not take a vacation. The Supreme Court did explain that such recovery could take place in a warm climate as well as in a New England winter. That being said, vacationing while on FMLA leave may take either permissible or impermissible forms. An employee recovering from a leg injury may sit with his or her leg raised by the seashore while fully complying with FMLA leave requirements, but may not climb Machu Picchu without abusing the FMLA process. Here, the employee was awarded back pay, front pay, emotional distress, punitive damages, and liquidated damages, as well as all the attorney fees. Recommendations that we as HR have for you as an employee: please be familiar with the FMLA laws and how to protect yourself. Let us know as soon as you might need to apply for FMLA so we can balance everything out. We are here to support you. Never be afraid to apply for FMLA, for it is a constitutional benefit that you have. And if you believe that your rights have been violated, please let us know immediately. We're here to help you any way that we can. Here's information reference to sources that I obtained in order to present this information to you.